Ms. Stiglish is going to be addressing the rights of unaccompanied children in immigrant proceedings.
Thank you. It's wonderful to be here, and it's so nice to see so many of you interested in this really meaningful topic. The children who will benefit from your representation, if you're a lawyer, if you're a law student coming into the profession, making sure that you carve out time to do this public interest service or others, is just wonderfully important. And I want to thank the organizers for putting together such a rich, thoughtful day. So before getting into kind of the nuts and bolts of representation and working with immigrant children, I want us to take a step back and just think about the immigration system and why children are even included, subject to enforcement provisions. This was a system largely designed for adults. And in all other legal areas, we think about adults being responsible for their own actions and kind of the legal framework, consequences in the criminal setting, in tax violations, and kind of other civil remedies. That consequences befall on those who are the decision makers, and in most aspects, that is the adults. Even the juvenile justice system is designed as a rehabilitative system with its faults, but the sense was that children should not, are not responsible, aren't even mature enough, their brains haven't developed enough. And in society, we don't want to just penalize children, but rather help them in their way. Immigration is wholly different, and even though, as you've probably heard already, this is a civil system, the consequences feel very punitive, and the circumstances of detention, even for children, are also very criminal in nature versus the civil context. So with that in mind, children in the immigration system is really an anomaly. Again, even the immigration system was designed for adults. And in the past decade, I'd say, there's really been a large number of advocates, of policymakers, rethinking how to better respond to children and the increased numbers of children in the immigration system. So from the very beginning, I know this was probably touched on a little bit in the last panel, of the rights of children in detention. And when they are first identified by immigration authorities crossing the border or arriving in an airport with a questionable visa or faulty documents, that apprehension does trigger certain rights. And as a child, they'll be issued an advisal sheet, and they do have a right to contact their consular office in order to provide assistance. They are advised on that sheet of their right to counsel, not at government expense, so counsel is not going to be provided to them. There's a question as to whether they will be able to contact a family member for assistance. So they are at least provisionally given this letter, this notice of rights in their own language, but monitoring that and making sure, particularly because counsel is not provided at that point in time, enforcement of even the giving of the notice, making sure that children understand what their rights are, enforcement is almost impossible. Mexican children are even provided a different screening, and Mexicans have always been treated differently, largely before the Trafficking Victims Protection Reauthorization Act in 2008. Mexican children who appeared at the border were routinely just sent back. Occasionally there was notice to the consulate and notice to the child welfare authorities in Mexico if there were concerns about the child's safety. But in most cases it was just a child under 18 who was Mexican national, came into the United States, was identified, and they were just kind of tossed across the border with the same regard as an adult. So there were no real special precautions taken for Mexican children. With the TVPRA, at least gave bit of rights in terms of screening for safety concerns Mexican children, so that there is suggestion that if the Mexican children make an affirmative statement, or the context is that there's a suspicion that they might be involved or a victim of trafficking, they can be transferred to the Office of Refugee Resettlement and placed in regular removal proceedings. The concern with that, of course, is that, again, we have Border Patrol officers or ICE officers, so enforcement officers who are doing this screening. And as in thinking about the best interest of a child, and in thinking about trying to, from a child welfare perspective, you really want that to be separate, not done by an enforcement officer, but being done by a child welfare expert, which is not being done. The Trafficking Victim Protection Reauthorization Act from 2008 for, again, Mexican children who are identified as potential victims of trafficking, and all other children. Hello? And all other children of other nationalities requires that they be placed in removal proceedings, in deportation proceedings. Again, which is problematic. It's initiating something that's that is, procedural and potentially punitive in nature in terms of deportation, without guaranteeing counsel. But that is the safety provision that at least will put them in proceedings and give them they'll have an ability to access counsel. They are also transferred to the Office of Refugee Resettlement, which you probably heard of on the last panel, in terms of being placed in shelter provisions, in shelter settings around the country. Per a settlement agreement back from the 90s, the Flores settlement, that allowed the release of children to a responsible adult, and that could be a family member. So there is a right, even though the child is in detention, there's a right to be in the least restrictive setting while in federal custody, and then a right to be released to a family member or other responsible adult. In the immigration courts, which run parallel to the custody question, but in terms of the immigration courts and children's rights in immigration courts, the question of ability to access justice is still very much compromised. As I mentioned, these are civil proceedings, so there are no separate rules for appointed counsel, whether you're a child or an adult. And right now, the statute and regulations still only give a right to counsel at not at the government's expense, so at the child's own expense. And there can be, continuances or time being given by the judge in order for the child to access counsel. But the idea of a child going off on their own to hire their own attorney is, again, something that's antithetical. You talk to any contract attorney and they'll question whether even the child has the ability to retain counsel. So to put that weight on a child is just kind of antithetical to most court systems, and a real question in terms of due process. To that end, in the Ninth Circuit, there's currently pending a class action lawsuit seeking appointment of counsel at government expense to ensure that children have counsel in removal proceedings. That litigation follows on the heels of similar litigation that was successful, that is now requiring the government to provide counsel for mentally ill, detained immigrants as they face removal proceedings where there are questions of competency. So where the immigrant is found to lack competence and counsel can be appointed. And I think in the same vein, where there is, where children as a whole under 18, there's a question of their competence to pursue and, really represent themselves, which is what they would otherwise have to do. The importance of having government-funded counsel for that population is key. So that litigation is ongoing, and while we're all very hopeful for it, I think it will be slow. But we have seen changes in terms of a government willingness to even to at least consider the potential for appointed counsel for children. In terms of that right to counsel, the TVPRA actually has language in it that that requires the Office of Refugee Resettlement to provide access to counsel to the extent that they can. And so we have seen in the past few years the Office of Refugee Resettlement using their funds to secure counsel, access to counsel provision for children in detention, as well as those who were detained and now reunified or family members. So if to the extent there's not an appointed counsel system yet, there have been strides made in terms of right to counsel where the Office of Refugee Resettlement is funding certain programs. In terms of, the right to seek relief, that is a key right that my co-panelists will speak to in terms of the relief that we see. But while are in court, children, similar to adults, have the right to pursue any remedy under the law. They have the right to call witnesses. They have the right to examine evidence. Again, all of this is maybe questionable and fairly empty without the assistance of counsel. When you're talking about can an 11-year-old or let alone a 17-year-old really examine the evidence that's presented against them or put together an application and seek relief in a language that they don't speak without the assistance of an interpreter or an attorney to assess eligibility. We have seen successes in terms of motions to terminate where the government has failed to at least provide rights or has somehow violated the rights and responsibilities that they do have regarding children, which includes service of paperwork of the notice to appear and advisals as to when the next court hearing is. So some of those procedural protections that children have attorneys have been successful where the government has failed to follow those procedures and been able to argue that even something that wouldn't to an adult perhaps be fatal because we're talking about a child, those procedures are much more important in terms of being a requirement versus just guidance to the court as to how it should proceed. But the one thing that we are sorely lacking is the best interest of the child as a standard. And this would, in terms of, from the very beginning, radically change the way children are brought into the immigration enforcement system and their rights. If there were the right to consider the best interest of the child at every stage, we would have a much improved system in terms of involvement of child welfare at the initial screening stage, involvement of child welfare in terms of placement decisions where a child is placed with whom they are reunified, appointment of counsel, and then in terms of assessing the options that a judge actually has in order to comport with the best interests of the child in terms of an outcome. So right now, if a child does not fit into one of the remedies that my co-panelists will discuss, special immigrant juvenile status or asylum, but there are other concerns that compromise the safety of the child's return to home country, a judge is really hampered in his or her ability. There is no right currently of a child to stand up and say, I know I don't fit into the framework of legal relief right now, but there are other separate reasons that I'm concerned about going home. My safety is compromised, and I need to stay here, or at least I cannot, be deported. And to have the judge consider those options and be able to, decide to close a case or not continue prosecuting the case or entering in a removal order, that, we always argue a judge can do and has the discretion to do, but it's not required. And I think to move the next step forward and to really focus on clear rights of the child in this context, we need that best interest of the child as a legal obligation that the courts work toward. And that would at least be one step in bringing the immigration courts and the immigration system in line with the other legal systems, particularly the juvenile justice system. Thank you.
Thank you so much, Ms. Steglish. So now we're going to open up to any questions people might have specifically about what was that? Oh, yes.
You talked about counsel being appointed for mentally incompetent persons, and the request for the right to counsel for children who I guess are incompetent, would be considered incompetent.
Yes.
Are those counsel, do we counsel or guardians ad litem?
So that's an interesting question. The way it's being implemented right now for the mentally ill individuals is their counsel. I think there are advocates, and you really do need a guardian ad litem to help direct the counsel, because absent that you don't have a decision maker, right? You need a client, so to speak. That's not the way it's being implemented, and I think there are real challenges in that. But at least it provides, one step in the right direction, and I think in policy and as it's being implemented, that question will be pushed. We've litigated cases with adults who have been found incompetent, and we've had one judge who has, we've gone with a guardian, a proposed guardian, and the judge agreed and appointed a guardian so that she was able to be our client and direct based on the best interests of the man who was found to lack competence. And I think a similar system could be set up for children. But right now that's not the way it's being implemented, which, it does have some tension in terms
How
of.
does counsel do that? I mean, I guess that's the regular, that's the quantity every time you represent a client.
Right. And a lot of the goals of counsel and the way it's being implemented is that judges are simply terminating cases, so they're just not proceeding with the case and leaving the person with a status quo. The need for a guardian really comes up if there is some relief to be obtained. For example, if the individual has an asylum case that maybe just based on their mental illness and country conditions could be seen, or in the case of a child, if it could be, say we're talking about a 5-year-old who, can't really guide and direct litigation as the normal attorney-client relationship could, that you would really need a guardian to say, yes, and this is what's happening in the country, and yes, this is what's in the best interest of the child, and then have the attorney be able to pursue an asylum claim, for example, based on that direction. And that's, one option in terms of working with the Young Center where that relationship could happen. Where they, in essence, are providing direction to the attorney based on the best interests of the child, as a guardian ad litem would.
Any other questions? I have one question, actually. Do you know what percentage of these children are going through the immigration system without an attorney, and what kind of the resulting percentage of children who are unsuccessful in any maybe meritorious claims they would have?
I don't have those statistics. I'm trying to remember whether.
I think it's about isn't it about 1/3 do have representation? I know that
New Jersey?
it varies by jurisdiction. I think it's about 1/3, but probably shouldn't even speculate. But I do know the difference in outcome. So whether a child is represented is the single most important factor in determining the outcome of a proceeding. Children with representation are 5 times as likely to prevail in their removal proceedings than children without representation.
Okay, so next we have Ms. Sarah Plastino. Ms. Plastino is a supervising attorney for pro bono programs at Kids in Need of Defense, also known as KIND. Ms. Plastino oversees the provision of in-house and pro bono legal representation to unaccompanied children throughout KIND's network of law firms and corporate partners in New Jersey. Ms. Plastino will be speaking to asylum as a form of relief for unaccompanied children.
Thank you, and thank you so much for having me here today. To the organizers, it's such an honor, and I'm really so pleased to see such a great turnout and real interest around this issue and synergy. And so I hope those of you who are inclined to accept a case for pro bono representation do in fact do so. My role is a pro bono supporting role in addition to my supervisory role in our in-house work. So I really have worked with a large number of pro bono attorneys, and so I can certainly speak to any questions you might have as a prospective pro bono as well in the Q&A session. So I want to thank Alyssa for setting this discussion up so well. I will be reviewing asylum and also T and U visa, which are 2 sort of victims visas as we call them. But really I just want to start by introducing our discussion to quote unquote remedies. So as Alyssa mentioned, the majority of children that enter the United States without their parents who are unaccompanied are apprehended and placed in removal proceedings. And so unless they can present a defense to that removal, they will be either ordered deported or granted voluntary departure, or maybe they will fail to appear and will be ordered removed in absentia if they don't actually attend their hearing. So unless they can determine what relief they're eligible for and put forward this defense, the outcome is not going to be in their favor and usually is not going to be in their best interest. So what Justin and I can hopefully accomplish today is to just give you a quick introduction to the most common remedies that the unaccompanied children pursue in their removal proceedings. And also, even if they're not in removal proceedings, if they're just in the United States undocumented but might qualify for some form of legal protection. The most common are the ones that we are reviewing, so asylum and special immigrant juvenile status, and also T visa for victims of trafficking and U visa for victims of serious crimes. There are other remedies like a deferred action or VAWA, the Violence Against Women Act. But for the new arrivals population, the children that we're specifically speaking about, the sort of children who came in the surge of last summer and since 2012 and the increase in violence, these are the most common remedies pursued. So just a bit about asylum. So asylum is for people who have a fear of return to their home country, a fear of persecution. Persecution is serious harm of some sort. And so basically these are, in the context of unaccompanied children, these would be kids who fear return to their home country because they fear that they would be harmed in some way. Maybe they have been harmed in the past, but maybe they have not been harmed in the past, and maybe they just have a future fear of persecution. And I'll get into sort of detail about what kinds of scenarios might lend to eligibility, but I first want to make sure you understand the remedy itself. So it is, if you're granted asylum, you become an asylee, which is a legal status, and it's sort of akin to refugee status, except the difference is that an asylum seeker applies within the United States, whereas a refugee applies outside of the United States. So this is if you win asylum, it's a permanent lifetime promise to not deport you, basically, from the US government, and you're authorized to permanently live and work in the United States. So it's a tremendous benefit, and it's really a protection from ever being returned to the country where you fear persecution. So if you're granted asylum, you also have the ability to become a lawful permanent resident and also a US citizen in the future. You do have to wait 1 year of having asylum status before you can apply to become a lawful permanent resident. Asylum also provides a variety of family benefits. So when you apply, you can list your spouse or children as derivatives on your own application. And this usually doesn't happen much for children, but you do get the occasional parenting child who may have migrated without their child in the home country, or may have migrated with their non-citizen child and is listing them as a derivative on their application. You can also apply for your family members later, even if you didn't initially list them on your application for a certain period of time. It also entitles you to certain benefits that refugees would also be entitled to upon resettlement in the United States. So you get certain cash benefits and sort of job training, other things that, that refugees get for a period of time. And also, while your claim is pending, you get eligibility for a work permit. Although in the context of children, we don't really do this that often, except for older teens might want to work and help support themselves. And so if they're permitted to work under the laws of the state, they can also obtain authorization through, during the asylum process. So those are all of the sort of benefits of asylum, but you also want to take into consideration the other important information about the remedy. So you are limited in your return to the home country if you are granted asylum. Basically, if you return to your home country, there's a risk that the U.S. government could allege that you're no longer afraid to return there, or that you obtained your asylum status through fraud. So it is something that's important to consider if your client is eligible for multiple forms of relief. Say they're eligible for SIJS and asylum, for instance. They need to know that if they want asylum, they'd be limited in their ability to return to their home country, and that might be an important consideration in their choice on what relief to pursue. Asylum is also discretionary, so if your client has some unsavory facts, it might not be the best remedy for them, so that's something to take into consideration. There's also something called the one-year bar, which applies to adults and accompanied children, but statutorily does not apply to unaccompanied children. The rule is that you would have to apply for asylum within 1 year of entering the United States to be eligible for asylum, with certain exceptions. But unaccompanied children do not have the bar applied to them, so that's an important thing to know. Also, asylum can be affirmative or defensive. So for the children who are apprehended and are actually in removal proceedings, it's that they're in a defensive posture. But for children who are not in removal proceedings, it would be an affirmative remedy, which is important to consider because if you apply for asylum affirmatively and your application is not granted, that actually triggers the initiation of removal proceedings. So if you apply for asylum when you're not in deportation proceedings and you don't win your case, then you get put in deportation proceedings. So it's definitely a risk calculation and something you really seriously want to consider evaluating the strength of the case for anybody who's applying for asylum affirmatively. So now just a bit about the statutory criteria and the legal standards. So in order to be eligible for asylum, you must establish that you have a well-founded fear of persecution on account of one of 5 protected grounds: race, religion, nationality, political opinion, or membership in a particular social group. Okay, so these are 5 distinct elements. You cannot conflate them. Each one must be established individually. So a well-founded fear basically means a reasonable fear. The Supreme Court has interpreted that to mean a 10% likelihood that you would experience persecution in the future. So it's a relatively low standard, but it's very complex legally and often hard to meet. Persecution is not defined by statute, it's defined by case law, and it generally means serious harm, but it's not just physical harm. Think about it in terms of psychological harm, and for children, think about it in terms of developmental harm, emotional, psychological harm as well. So like child neglect, for instance, could be harm that's psychological, physical, and developmental in nature. The on account of element is called the nexus, which means basically you can't just fear harm for any reason. The harm that you fear must be on account of some protected status. So the protected status is also separate, but basically you have to prove that the reason that the persecutor is seeking to persecute you is on account of some protected characteristic that you possess. And then, so there are just 5 basically categories of protected characteristics: your race, your religion, your nationality, your political opinion, or your membership in a particular social group, which is the broadest and most legally complex of the 5 grounds, but it really permits you to assess the facts of your individual claim, determine exactly why that individual is likely to experience harm, and present a legal theory that very closely tracks the facts of your claim. So it's flexible, it's case by case, and there are an infinite number of social groups you could propose. So how do unaccompanied children fit within this framework? What are the most common claims that they pursue? So I just really quickly wanted to tell you the story of 3 children so you can get an idea of the kinds of claims that come before the court, before the asylum office. So Bessie and Melvin. Bessie is 5, Melvin is 14. They're from Guatemala. Their parents owned a small business, and gangs began extorting them for extortion fees, basically called the rent. And eventually their family was no longer able to pay, and one day the gang members stormed into their home while the 2-year-old Bessie was being held by her mother and murdered her parents. So the 2 became orphaned, and without the surviving family members were too afraid to take care of the children, so they began residing with their teenage sibling as their only caretaker. The gangs didn't stop targeting the family. In the middle of the night, a few months later, the gangs came and firebombed their father's car outside of their house. And you can imagine these children are at this age, they're 3 and 11. So this is, of course, a terrifying, life-threatening sequence of events for these children. They ultimately fled to the United States, and now they reside in New Jersey under the care of their older brother. And they are eligible for asylum and also special immigrant juvenile status. And they're actually represented by some pro bonos at a law firm that I supervise. So if you were to take a case, you may get facts similar to this. Just quickly, the second would be a girl named Nayeli, who's 15. She recently was granted asylum. She's from Honduras, and she's from the city with the highest murder rate in the world, San Pedro Sula. And her neighborhood was physically run by gangs. They had a barrier that they sort of lift and put down anytime anyone tries to enter the neighborhood. And the leader of the gang started targeting her older sister, stalked her, kidnapped her, and raped her on several occasions while Nayeli was present in the home when they came to their home to kidnap her older sister. And when her sister began resisting more and more, they started targeting the then 14-year-old Nayeli, and she and her sister together fled to the United States and now live in New Jersey and are also represented by were represented by some pro bonos with Kind, and now she was granted asylum and her removal proceedings were terminated. So these are the kinds of cases, it's really common fact patterns. So when you're trying to assess whether a child qualifies for asylum, if they all were a victim of child abuse or neglect, if they were a victim of physical abuse in any way, if it was by a caretaker, if it was intimate partner violence, any sort of domestic violence, child abuse in nature, that could form the basis of an asylum claim. Also, if they were neglected, this is something that a lot of practitioners don't think about because they're thinking through an adult lens. But when you think about a child's claim, if you have an 8-year-old who doesn't have food, whose caretaker isn't providing them food, that can be persecution, whereas for an adult, that wouldn't be, right? They can get their own food. Also, we have a lot of gender-based violence happening and sexual violence in the northern tribal countries in Central America. So we do see a lot of sexual violence-based claims like Nayeli's claim. Also, gang recruitment is very common. Often children, both boys and girls, are targeted for gang recruitment or forced drug sales. They're often targeted at school. It's extremely dangerous for them, and usually when children come of a certain age, if they live in certain areas, they really have no choice but to join the gang or be killed or come to the United States. Also, if they were ever psychologically or emotionally abused, if they were ever threatened with serious harm, if they received death threats, if they were homeless, if they've had any interaction with police in their home country. I have one girl on my caseload who the police threatened to rape her and disappear her. So, she's El Salvadorian, little 15-year-old girl. If they were ever forced to perform labor or trafficked or, were subjected to a child marriage. All of these scenarios would lend eligibility for asylum. And I really also want to stress, think about the lack of a caretaker. If the children are going to be returned to an environment where there's no adult to take care of them or no fit adult to take care of them, that could lead to a situation where they would be extremely vulnerable to exploitation, which could also form the basis of an asylum claim. So even if a child has not been persecuted in the past, you can also establish eligibility through future fear alone. So think about the situation that the child is returning to, and especially if there are any individualized targeting of that child, then that claim would be even stronger. Procedurally, initial jurisdiction over an asylum claim for an unaccompanied child lies with the Asylum Office, which is part of USCIS in the Department of Homeland Security, so it's a different agency than the immigration courts. So they basically get the first bite out of the apple, and if the Asylum Office doesn't approve them, then the child has a de novo proceeding before the immigration judge. So procedurally, what happens to trigger the claim, you file the asylum application, and then the child is interviewed by an asylum officer, and then the asylum officer issues a decision. Now, currently, the Asylum Office is prioritizing unaccompanied children's claims, so they're actually moving very fast, which is great, and it's a real departure from previously, whereas even about a year ago, children had to wait several years and were really very rarely even interviewed, and now you can get a decision within about 3 months. So it's really a great time, and we are having real favorable adjudications, so I do want to sort of urge you, if you do have clients that are eligible, don't sit around because they're getting older, their claims are getting stale, and right now it's a really good time. Also, I mean, of course, you have to think about all the various considerations in your individual claim, but so the real bulk of the asylum representation is in the pre-interview submission, which generally includes an affidavit of the applicant, which in this case would be the child, and with our kids' claims, we usually provide an affidavit of the adult caretaker or anybody else who might be a witness, along with a letter brief arguing the eligibility of the child for asylum and any other evidence supporting or corroborating the claim, such as country conditions documentation, documenting the risk of harm or the pervasive nature of the persecution that they have suffered in their home country. So, in terms of interaction with removal proceedings, you do not have to wait until the child has actually had their first master calendar hearing to pursue asylum. This is something that I get from my pro bono attorneys all the time. It's a really common misperception. Oftentimes, children have to wait several months after being released from a shelter to have their first master calendar hearing, but in the interim, they can be preparing their applications for relief. They can file for asylum. You do not have to wait, okay? And then if your asylum claim is pending while your removal proceedings are active, the immigration judge will just grant you a continuance to permit the adjudication of the asylum claim. So they're sort of parallel processes. As a pro bono attorney, your role is extremely important. As you can imagine, I've just outlined a very complicated legal scheme. The burden of proof is on the applicant. The interview is, several hours long sometimes. And asylum seekers are some of the most vulnerable of the children who come to this country. They may have experienced trauma or torture. And the stakes are extremely high, right? If they lose their case, they most likely will be returned to a situation where they're in very real grave danger. Just in terms of hours for pro bonos, if you're considering this, KIND estimates that the average hour caseload for an asylum proceeding is 80 to 100 hours for a pro bono representation. And also, if you're thinking about it, asylum is very quick relative to other remedies such as SIJS. Sometimes it can drag out for like a year and a half or 2 years. So if you're looking for sort of a brief service, if that is possible in this proceedings, asylum might be one at present. And also, as I was saying, they're very favorably adjudicated. We're looking at about a 57% adjudication, a favorable adjudication rate nationally, so that's pretty high. Very quickly, T and U visas. These are some of what we call the victims visas. T visa is for children who are victims of severe trafficking in persons, so this would be either labor or sex trafficking. The situations that you would see for unaccompanied children, the most common, we have a lot of Mexican boys or also non-Mexican boys, Central American boys, who are forced to traffic drugs into the United States by their smugglers or the cartels along the border. Also, sex trafficking, of course, is a phenomenon that we all are constantly screening for and does befall some unaccompanied children. Also, children who may have incurred a debt through the smuggling process. Their smuggling may then turn into trafficking if their smuggler is forcing them to work in order to repay the debt, and sort of the indicia of trafficking are present in that type of scenario. So these are kind of the most common that we see in our practice. I am representing currently a Guatemalan child who, when he was 16, was kidnapped by the Gulf Cartel in McAllen, Texas, and detained in a trailer for 3 days while they extorted his family members, and then they forced him to carry a backpack of unknown contents, which of course I suspect to be probably drugs, through the desert for 2 nights. They put it on him at gunpoint. They followed him behind with guns, and he had no choice. He was just a mule. So that's a really common scenario. Quickly, just eligibility. It has to be severe trafficking in persons, which is labor or sex trafficking. If the trafficking happens to a child, they do not have to get, they do not have to prove that they have been helpful to law enforcement in the investigation or prosecution of the crime. But if you're an adult, you do have to prove that. But you do not need a law enforcement certification, which is different from the U visa. You do need a law enforcement certification, even if you're a child. You also have to be present in the US on account of the trafficking, and you have to suffer extreme hardship upon return to your home country. So that's a T visa. It's really great in terms of family reunification. So if you're a child and you're a child applicant, you can also apply for your parents and all of your minor siblings to come, even if they're in the home country. And you can even do that later after your T visa is granted. You don't even have to do it initially. The T visa and the U visa are both 4-year-long visas, and after the 3rd year, the principal applicant and the derivatives can sort of, it's complicated timing-wise, but basically after 3 years, they can apply to become lawful permanent residents and then eventually US citizens. Also, for U visa, the child has to have been a victim of a crime in the United States. The crime has to be one of certain qualifying crimes. It can't be any crime. It has to be a serious crime. They have to have suffered substantial harm. And also, they have to be in possession of information concerning their criminal activity and be helpful to law enforcement. So, but if the child is under 16, somebody else can be helpful to law enforcement, but someone has to be helpful to law enforcement. And you have to actually get a certification form. So you have to convince law enforcement to sign this, which is often in practice quite difficult. So we have a hard time with U visas. You would see, in certain circumstances, they're easier for unaccompanied kids. Like in Alyssa's practice, they work a lot with children in the child welfare system. So if a child has been removed from the home, has suffered child abuse or sexual abuse, that would lend eligibility for a U visa. Also, we see a lot of abuses at the border, some by US government, some by non-state actors, and those are a lot harder because the resources at the border are really not necessarily in favor of the vulnerable undocumented migrants. So I just wanted to say a quick note about pro bono. These cases are extremely rewarding, as I'm sure you can tell. The need is huge. I'm not sure what was said earlier about the numbers in Pennsylvania, but last year, Pennsylvania in 2014 alone received 660 children released to adults residing in Pennsylvania. So that's a huge number. As I mentioned, representation is the single most important factor, 5 times more likely to win if you have representation than not. In terms of bang for your buck and buck for volunteer hours, this is really where it's at. The timing is now. These cases are moving faster, they're being prioritized, and without representation, it's really impossible for a child to put forward their own defense. So I'm happy to answer any questions, and thanks so much for your attention.
Any questions for Ms. Blessian?
I hate to ask all the questions. Is a person who is fleeing the gangs considered to be a member of a social group that's recognized for asylum?
Great question. So some of the most challenging case law from our perspective surrounding gang recruitment claims for largely boys from Central America. There's some negative case law that has been issued over the course of a very long period of time, and most recently from the Board of Immigration Appeals. But what we're seeing is we're seeing favorable adjudications when the child can enunciate an individualized reason why they were targeted, rather than saying, well, they target all boys my age, for instance. If you can say, I think they targeted me because I am active in my church, and they wanted to recruit people from the other side, the good side, to their bad side. I mean, that's a real common thing in terms of a recruitment pattern. I have one boy who said, I think they targeted me for forced drug sales because I'm on a soccer team and I'm I'm an upstanding citizen in the community and I would be an unsuspected person to be engaging in criminal activity. So if you can sort of ask the child why they may have been targeted as an individual and formulate that into the basis of either another protected ground, like religion, for instance, or another social group, maybe boys perceived to be upstanding citizens. Just sort of snowballing here. But I mean, it's not like you're crafting a social group that has no basis in the facts. What you really want to do is really dig into the facts and then figure out why, in fact, this child was recruited.
Sir?
Can you talk about what the burden of proof is for an individual applying for these T visas to prove that they're not a part of a drug cartel or whatever it may be?
Maybe you guys can help me here. I mean, it's discretionary, of course. There are certain disqualifying grounds. I don't think there's an immediate sort of presumption that one would be engaging in criminal activity. In the situation that I presented with my client, for instance, the child who was forced to traffic something, perhaps drugs, there are certain grounds of inadmissibility that could conceivably be applied to that scenario. So, for instance, if he was labeled as a drug trafficker, then that would be a ground of inadmissibility at the adjustment of status phase. So that's basically when somebody's applying for their green card, there can be certain disqualifying grounds of inadmissibility, they're called. One is if somebody has been a drug trafficker. But, you know, there are a lot of arguments that you can make, and, you know, he didn't know what the substance was, it was under duress, he's a child, he didn't have capacity to have intent. So there are a lot of kind of ways that you can argue against the application of some of those more punitive bars that really aren't intended to exclude people in the victim scenario. I hope that answers your question.
And it's clear and convincing evidence for most of the USCIS applications. You know, interestingly, with the T visa and the U visa, there's no interview. So you don't have a lot of the kind of credibility questioning that you find in the asylum context, where there is an interview or, you know, a judge adjudicating it. For the most part, if there's, you know, other supporting documents in addition to the detailed affidavit, detailed statement, then there's, you know, an assumption that they're telling the truth. And usually having for T and U, the involvement of law enforcement helps, you know, give the credibility to the application.
Yes, if you arguably qualify for the T visa and the D visa, should you try to go after both of these, or should you focus on one of these?
Yeah, definitely. You should go after all relief that you are eligible for if you have the capacity to pursue them simultaneously. And there are certain considerations, but for T and U, you can certainly apply concurrently for both. U visa, your ability to apply would depend on your ability to obtain the law enforcement certification. But with T visa, you can apply even without that. You just, if you're over 18, you just have to establish that you were, that you reported and were helpful in other ways. You can do that through your own statements or through other sort of documentation of your attempts.
And there might be practical considerations with one versus the other. For example, right now there's an almost 2-year wait time in order to actually obtain the U visa, even if you know it's going to be approved, because there's a statutory limit of the number of U visas. Also, the benefits that you get with the T visa are much more generous in terms of access to public benefits and more supportive, particularly if you're a child. It would probably be more beneficial to do T versus U.
Also, to follow up, I guess, for both T and U visas, to qualify as a child, should you apply while you're a minor, or
Yeah.
should you apply? Should determining factor be like that crime happened while you're a minor, or when you're 5?
It's the date of application. It's not when the trafficking took place. So say you were trafficked when you were 16, as long as you applied before your 18th birthday, you'll be considered a child for purposes of the adjudication.
So with regards to some of these cases that are falling through the cracks when you're applying for asylum, obviously Philadelphia's not the point of entry, right? But what do you think's happening? I mean, living in Honduras, I meet a lot of kids that clearly have a case. Are they not justifying their case? Do they not have proper representation? What do you think's happening in some of these courts, in some of these cases?
Well, if they don't have representation, it's very difficult to present a claim pro se. It's legally extremely technical, and you really don't have even the ability to conceive of and present a legal theory. So all you can really present is the facts. So if you have an officer who's not inclined to grant on the facts and needs to be persuaded, there's no one really to persuade. Also, the case law is unfavorable on gang-based recruitment claims, and so the lawyering really has to be creative and really dig into the country conditions, and that takes a lot of resources and a lot of brain power. So if you're applying pro se, it's extremely difficult as well. Yeah, I mean, it's so hard to even know what to do if you don't have representation, and with the representation rate so low. Convincing someone to represent you for free is very hard unless you're connected with a nonprofit like those of us in the room. So yeah, I imagine that for you it must be really challenging seeing all these young people who really are in need of protection and are not receiving it. So I sympathize.
Thank you so much, Sarah. Finally, we have Justin Mixon. Mr. Mixon is an immigrant youth attorney at HIAS. He provides direct legal representation, know your rights trainings, and legal screenings and referrals to unaccompanied children in the custody of the Office of Refugee Resettlement.
Thanks, and thanks for having me here. This has been a great day for me. I've learned a lot, too. So I work at the Hebrew Immigrant Aid Society, HIAS, Pennsylvania. And here in southeast Pennsylvania, really all of eastern Pennsylvania, we are what's called a legal service provider. We get a little bit of federal funding, not much, to go to the shelters where, we were talking about the Office of Refugee Resettlement through the Department of Health and Human Services, which is a nicer place for kids to end up. And fortunately, since the Flores settlement, that's where the unaccompanied kids go. So when a child crosses the border and is caught by Customs Border Patrol, they can only spend 72 hours there, and then they have to be sent to one of these shelters somewhere in the country. And it doesn't correspond to they're not being sent to Pennsylvania because they have a family member in Pennsylvania. They're being sent because there is a bed space here at a shelter, and there's not bed space in Denver or Seattle, So kids arrive at these shelters in eastern Pennsylvania, and we go and we teach the kids about their rights. We interview each individual child and screen them for legal relief. And then some of the kids, now there's a new program, Continued Representation, where we get a little bit of money, not much, not really enough to pay the bills or anything, but to represent individual children who, when they leave the shelter, they stay in Pennsylvania. A lot of the kids who come to shelters in Pennsylvania go to another state. They're going to meet up with a family member in Houston or Los Angeles or somewhere else. I think a lot of politicians in Pennsylvania, when they heard that there were these shelters in Pennsylvania, they assumed that all the kids were going to stay here. They got worried somehow this was going to cost a lot of money. But really, most of those kids are going to other states, and they're not. Once they're released to their family members, they don't really cost anyone any money. But the special immigrant juvenile status. So I just wanted to explain my role first. Where I'm coming from. So when we meet these kids, we have the most success in Pennsylvania anyway with special immigrant juvenile status as opposed to asylum or T visas or U visas. It's a little bit more common remedy. It's an unusual remedy because it requires a state court that has jurisdiction over children to do something. And the state court judges are often confused, and they wonder why I'm in their courtroom and why this can't just be handled in immigration court. Because it's an immigration law, but it's been on the books since 1990. The idea of special immigrant juvenile status is we, as a government, don't want to deport children to places where they are likely to suffer abuse, abandonment, neglect. So basically, the eligibility requirements: if you are under 21, if you're unmarried. And if the child is the reunification with one or both parents is not viable, and this is the statute, not viable due to abandonment, neglect, or abuse, and it's in that child's best interest to stay in the United States, and not in the child's best interest to go back to their home country. So that's a statutory requirement. And USCIS, the immigration agency, will adjudicate that special immigrant juvenile status application, but they will only do that after a state court, and in Pennsylvania that's usually dependency proceedings or custody proceedings, after a state court has acted to show that the child was abused, abandoned, or neglected by one or both parents, and the other statutory grounds. I mean, the state court has to actually make those findings of fact. In other states, you can sometimes do it with guardianship. We've heard of sometimes even delinquency proceedings where a child, a teenager has ended up in juvenile delinquency because of something they did, and then the judge, while they're looking at their delinquency case, and somebody advocating for the child realizes the child is undocumented, and they also have this abuse, abandonment, or neglect. So children are out there and they're kind of under the radar sometimes, and they might pop up at different county child welfare organizations. We get calls from child welfare organizations, the county agencies sometimes, that, there's a child, we've been servicing this, we've been helping this child for 4 years now, and we just realized they're undocumented. and we heard that we should call you because maybe you can help them get a green card, So they don't remain in the United States undocumented for, and all the drastic, the horrible things that happen if you're here undocumented as opposed to having a green card. So we can then help the child welfare agency do what they need to do to get a finding from their dependency court judge that has these findings about abuse, abandonment, and neglect, to make the child eligible. And then we can help the case in immigration with USCIS, and then also immigration court. So there's really 3 different places where this is happening, and they're all needed. So you have to go to state court. You have to tell the immigration judge, hold on, I need a continuance so I can go to state court. And in state court, whatever you're doing, whether it's dependency proceedings or custody proceedings, and I'll explain more about that in a minute. And then you get that, you go to USCIS, you get them to adjudicate, which is actually the easy part. Once you have the state court order, USCIS usually goes along with it. Although there are some issues that will come up only with USCIS. And then once USCIS says yes, the child, special immigrant juvenile status, you can get the proceedings terminated in immigration court, and then pursue the remedies through all your remedies, the rest of your remedies through USCIS, and the child eventually gets a green card and can apply for citizenship after a certain period of time, like everyone else that has lawful permanent residence. So the pros and cons, there are some cons, and this sometimes goes into the decision about whether it should be asylum or special immigrant juvenile status. Although I believe in most jurisdictions, special immigrant juvenile status, you're more likely to succeed than asylum. It depends on the case. One thing that can lead you to apply for asylum, if you have a good asylum case, instead of special immigrant juvenile status, and I'm just going to start saying SIJ because I'm tired of saying that, or SIJS. So is because what happens is the child applying for SIJ, that parent, any parent actually of the child, cannot receive an immigration benefit in the future from that child. So let's say the child, gets citizenship, stays in the United States, turns 21, and could maybe sponsor a parent. Not if the child got their status originally with SIJ. And so if you have a really good asylum case, you want to do that instead. It's discretionary, so it doesn't happen very often, but there is the possibility you might win in state court on abuse, abandonment, and neglect. Go to USCIS. USCIS says, there's no criminal convictions for this child, and juvenile convictions don't count as criminal convictions, but because it's discretionary, and we see there's this juvie history of, theft, graffiti, whatever it is, we aren't interested in, granting this discretionary relief to this child. We don't see that much in Philadelphia, fortunately. So here in USCIS in Philadelphia has been very fair with these applications and has seen them in many different forms. They get to look at orders from dependency proceedings, from custody judges. They see orders that are even created by stipulation. And those we try to counsel pro bono attorneys and attorneys to try to get the judge to put the findings into the custody order as the judge making the findings of fact. So I don't know, is there anyone in here that has done custody work in custody proceedings? Okay, so not very many. But one thing that happens commonly in custody, just regular custody court where two parents are fighting over a child who gets custody, is that if the parties can come to some sort of agreement, the judge will just sign off on it, and the judge won't make findings of fact. Well, for special immigrant juvenile status, you should try to get the judge to make those findings of fact, because USCIS may give you trouble later on when you're trying to adjudicate that application. Because a lot of custody attorneys, when they get these cases, they want to just do the by agreement stipulation thing that custody attorneys often do. Dependency proceedings, so I represent some children who don't have a family member to reunite with, and they are at the shelter, and then there is something called federal foster care that they can go into, but you have to win special immigrant juvenile status for them first before they can go into URM, the Unaccompanied Refugee Minors Federal Foster Care Program, which Lutherans runs that program here in Pennsylvania. They have a great URM program, but we have to, somebody has to win their SIJ case first, and usually that's in dependency proceedings. And does anybody practice dependency law in Pennsylvania? Okay. So, it's the child welfare system. So when there's a report made by a school teacher, this child, it seems very tired, depressed, there's something going on, they talk about abuse at home, some sort of a report is made to the county child welfare organization, then the child welfare organization files a petition for dependency in Pennsylvania. And through that process, the child is declared dependent. And so that used to be the only way you could get special immigrant juvenile status nationwide, until the law was changed so that you didn't have to be dependent, you could just be placed in the custody of the wording is very unusual in the statute. I'm trying to remember. So it's in the custody of an agency, an individual. So that's why you can do it through custody, delinquency, guardianship. You can use some of these other courts that have jurisdiction over children. It used to be the case that the child had to be one of these child welfare cases. And that's where the courts are more used to dealing with abuse, abandonment, and neglect in that kind of child welfare setting. So that's why it's difficult sometimes for the attorneys to make a case in custody court. Custody court will say, why aren't you in dependency court? Well, that's because the child is with one of the parents. You can't be in dependency court if you're living happily with one of your parents. So anyway, there's just a lot of things to consider. It's a complicated area of law. I mean, we're all trying to do this, our little, area of the law in a very short period of time here. And I'm very happy to answer lots of questions. I think there was one more thing I was going to, age out. In Pennsylvania, it's important that the child start this process, long before they turn 18. Hopefully, right? Yeah, yeah, right. You're only going to get the cases where the kid's going to turn 18 in the next month, right? Yeah, that's what we give to the pro bono attorneys. Just kidding. So, no, I'll get stuck with that one, and we'll give you the good ones. So, in Pennsylvania, you've got to have that dependency order before they turn 18, because in Pennsylvania, there is no dependency adjudication after you turn 18. You can get services after you turn 18, but you can't get that adjudication. Custody in Pennsylvania, you can't have custody normally of a child after they turn 18. And But in other states it's different. You know, in Maryland, children get lots of different court adjudications that there's lots of court jurisdiction that can be used for special immigrant juvenile status until you're 21 in Maryland, and in the state of New York, it's complicated, but for the most part, until you're 21. But those are two of the only states that have that. Many states have 18 as a cutoff, so even though special immigrant juvenile status, the immigration law, if you get one of these cases, you'll say, oh no, but it's under 21, but really, realistically in Pennsylvania, it's under 18. And you've got to start in anticipation. You can't wait until the day before they turn 18. So, and then, you know, if you get a case from us or from somebody else, there are logistical issues about service of process and how you're going to get the evidence to convince the judge that the child was abandoned, abused, and neglected. I mean, it's similar to asylum. You do the best that you can. It depends on the judge. You know, some judges are willing to just go on a lot of testimony from the child. Some judges want more evidence. Some judges are going to require personal service of process in that other country, which is difficult, but we have resources for you. Call us, email us if you have those sorts of issues. And so, before we go into the questions, can I make an advertisement? Like 2 or 3 advertisements. I've got lots of advertisements. Number one, if you like these issues about unaccompanied kids and everything, Sonia Nazario, Pulitzer Prize winning author, is speaking at our big annual fundraiser, April 20th. You can come see her. You can just pay the $50 ticket, and then you miss the first cocktail hour or whatever. But you get to see her, and you get to hang out with me afterward. I've got lots of these cards out there. That's advertisement number one. Number two, we were talking about the Berks County residential facility, which is, you know, detention, ICE detention, and its horrible conditions. And the last panel here, you got to see just how insane this system is, and these people don't need to be detained. These are women and children who have asylum claims. There's no reason to detain them. The Obama administration is detaining them in this idea that they're going to somehow deter more people from coming. We're helping with a lot of other organizations and pro bono attorneys to organize this big protest on May 2nd. It's going to coincide with protests at Carnes and Dilley, the larger facilities in Texas. So I'm sending that sign-up sheet around for the protest. If you put your email on here, once we know exactly what time and where, I'll email you. Lastly, if you're an attorney or a social worker or an interpreter or whatever, really, just about anybody who wants to volunteer and get involved and help with refugees and immigrants, those sorts of things. We work right here in Pennsylvania, Philadelphia. I'll send out that volunteer sign up as well. Sorry about all the advertisements. Sure, I'll take yours.
Great.
Since I gave you the sign-up sheets.
You mentioned that an immigration judge has to agree to suspend the proceedings so you can go off to state court and stuff. Do you have to make some showing that you're going to prevail in state court, or do you pretty much get the chance to go there? I mean, you know, so many things in the law sort of require you to show that you're going to win before they give you any relief.
In Philadelphia, I've never heard of anybody not getting the chance. I don't know about the other jurisdictions. Yeah, I think everywhere you get that opportunity. You know, the judges might differ on how much time you get. It might hassle you more about like making you come in every month, every 3 months, you know. And some of the courts in the nation are doing this rocket docket thing where they're pushing the kids' cases constantly in master calendar. Yeah, but that's not happening so much in Philadelphia.
And when you go off to state court, how long does it usually take to be heard on?
Yeah. Well, I mean, so I end up in these counties where I'm the first person that's ever done this. So, you know, I go to Lehigh County and they're like, what? Whatever you do in Philly, we don't do that here. So, you know, wherever it is I'm going, I'm like, okay, I get to be the first, you know. And so they might do what they're supposed to do with independency proceedings and follow a 45-day calendar because, you know, kids who are in need of protection, they should be boom, boom, boom. They should decide whether or not the child's dependent, start talking about where the child should be placed. Custody, ooh, yeah. So in Philly, custody could take 2 years. In Montgomery County, it could take a year. You know, the jurisdictions all over the state are really slow on custody because they're overwhelmed with all the parents fighting about their kids. Sometimes we can bypass that and get a little faster adjudication if we say to the court administration, yeah, this is going to be uncontested. The other parent's not even in the country, and we've got a stipulation. You know, that sort of thing. We can get it through a little bit faster. It could be all over the place. It could take a year. It could take 6 months. It could take 1 month.
Yeah, so,
Not much of an average, really.
so the immigration judge has no real knowledge of when you're going, how much time you're going to need.
And the immigration judge doesn't know how long it's going to take, and so you might have to go back a few times to get continuances. But what's nice about this whole procedure is they don't look. There is no federal court of family law, so that the feds understand, like, well, we don't. This isn't our area of expertise. Family law, that's the states. So whatever the family state court judges are doing, that's what they do. So who are we to question this? And they don't look at, USCIS doesn't question you about Pennsylvania dependency law. And, is this kid really dependent? They don't get into that. So the two kind of spheres are operating very separately and not questioning the other when it works.
I should say, that is not the case in New Jersey.
Sorry, that's Pennsylvania.
You all have it, golden here, golden children. No, in New Jersey, there's lots of going behind the predicate order. In a special immigrant juvenile status application, USCIS routinely interprets New Jersey law, routinely requests additional factual evidence submitted to the family court or amended state court orders, which are all very problematic practices that we are collectively advocating against in New Jersey and nationally.
Question. If the child is unaccompanied, so there are no parents involved, you become their attorney under Pennsylvania law. Could you be the petitioner of a child in need of protection?
Yeah, so under Pennsylvania law, there's this rarely used thing that's a private petition, which is there in case like the county agency fails to act. And you see it more in Philadelphia than you do in a lot of other places where DHS in Philadelphia, not big DHS, little DHS, in Philadelphia where they, child welfare, they are overwhelmed. And so maybe there's kids who need to be protected and DHS, for whatever reason, doesn't agree. Well, there's private organizations like Support Center for Child Advocates and other places that do these private petitions. So in the immigration context, that can sometimes be helpful because if a county child welfare agency says, we don't do that immigration stuff, and you as an attorney, family law attorney, immigration attorney, I do both, most people just do one or the other, you can, the private petitioner could be the child. Legally, under Pennsylvania law, the child can be the private petitioner. Or, my organization, Highest, could be the private petitioner, even though we're also the child's counsel. I get to wear a lot of different hats. It's a little bit crazy ethically sometimes because, I may be representing the mother and the children in custody. I may be the private petitioner and the attorney for the child. What I'm not a guardian ad litem. I just represent, if that child wants a green card, I hone in on how to get that child a green card, So.
I think we have time for one more question back there.
Yeah.
I was wondering what kind of family court order you get for one-parent petitions, saying if a child came into the country with father and mother who are both undocumented, but the child is under 18, and arguing that neglected or abandoned by the other parent. What kind of family court order? I don't know, custody or I'm not sure which one would work.
Yeah, in Pennsylvania, that's going to be custody. So the child is living with a parent here.
The father.
Okay, and then the other parent is in home country,
Exactly.
and that parent was either abused, abandoned, neglected.
Yeah.
Yeah, those we've been successful in a lot of those. Those are called one-parent SIJ cases, and You can even be successful in those cases where, let's say the child is 15 years old and the child was abandoned when they were 1. Basically, the child has never known the father. The way special immigrant juvenile status is written, the way the law is written, that abandonment by the father 15 years ago can still be used to help the child qualify for SIJ. Yeah, so it's just you have to be creative, and it depends on the state court judge that you get. And in custody court, you need a judge that has done this before, unless you want to be the first. So you can email me.
All right, I will. Thanks.
All right, well, thank you all for attending.